Pop culture loves the idea of the human lie detector. We see characters on screen who can glance at a suspect, catch a twitch of the eye or a subtle shift in posture, and instantly know they're hiding something. But bring that approach into a real courtroom, and it falls apart. The legal system explicitly rejects these intuition-based judgments as unreliable clinical lore, unvalidated guesswork that has no place when a person's freedom or livelihood is on the line. The gatekeeper that keeps this subjectivity out of the courtroom is a strict legal standard known as the Daubert standard. Established by the Supreme Court in 1993, Daubert mandates that any psychological evidence presented to a jury must be grounded in reliable methodology. It has to be peer-reviewed, statistically tested, and scientifically valid. The justice system demands reproducible proof. A forensic psychologist cannot simply claim to be a mind reader. They have to back up every assertion with rigorous, objective data. When it comes to the specific act of lying, you cannot reliably identify deception just by watching someone's behavior. Human behavior is incredibly varied. Cultural backgrounds dictate different norms for eye contact, and natural temperaments alter how a person builds rapport under pressure. There is no universal physical tell that proves someone is lying. This is a set of functional neuroimaging, or fMRI scans, showing 3D brain activity. Deception is a complex neurological process. When someone lies, they engage high-level executive brain systems to manage the fabrication, rather than just displaying outward physical tics. Because of this internal complexity, diagnosing an individual from a distance, or drawing clinical conclusions without an adequate and direct examination, violates core professional ethical guidelines. The mechanisms of deception and mental illness are hidden deep within the cortex and obscured by normal human variants. To catch a lie, psychologists have to rely on hard data rather than their eyes. In forensic psychology, the intentional faking or exaggeration of a physical or psychological illness for external gain is called malingering. This chart shows the expected test performance of a genuinely impaired patient compared to someone faking an illness. It illustrates the first scientific trap used to catch malingering, the floor effect. A malingerer often doesn't know which questions are too simple to plausibly fail, like forgetting their own date of birth. They intentionally fail tests that are so basic, they end up performing worse than genuinely, severely impaired individuals do. The second trap is symptom validity testing. This relies on forced choice questions with only two possible answers, establishing a statistical baseline where a person randomly guessing would score exactly 50%. Scoring significantly below that random chance threshold mathematically proves the subject knows the correct answer and is actively avoiding it. You have to know the right answer to consistently choose the wrong one. Identifying these patterns requires immense precision, which is why the courts enforce strict rules about who is allowed to administer these tests, guarding against what is known as a dual-role conflict. A patient's own treating clinical therapist operates as an advocate, focusing on well-being and recovery. That therapeutic alliance legally and ethically disqualifies them from serving as an objective forensic expert for that same patient. Admissible evidence requires a forensic expert to operate purely as an objective friend of the court. They utilize statistical traps and validated instruments, ensuring their findings are untainted by the bias of a therapeutic relationship. Even with rigorous psychometric data and perfectly neutral experts, the power of a forensic psychologist has a hard legal limit. An expert witness is strictly forbidden from answering the ultimate legal question of the case. No matter how overwhelming the clinical evidence, a psychologist cannot declare a defendant guilty, innocent, or legally insane. Their sole job is to evaluate the data and provide the court with an accurate, scientifically sound description of the person's mental state and cognitive functioning. The final application of the law to those mental states belongs exclusively to the judge and the jury. Forensic psychologists are not mind readers, nor are they final judges. They are scientific translators. Their true value to the justice system relies entirely on their strict adherence to these objective evidentiary boundaries.